So next is McNabb. Motion to revoke.
Your Honor,
Yes.
I do represent Mr. McNabb, and I just wanted to.
And I'm sorry, Your Honor, can we have a breakout room with Mr. Lynch? We have a negotiation. I just need to ask about if the court will accept.
Okay, hold on.
I could potentially save some time there.
Uh-huh.
At this point, Mr. McNabb is not accepting the recommended, the newly negotiated recommendation that you presented, Ms. Ponder. So I don't know if that.
Okay, so that means we're going forward with the hearings.
That is my understanding, Judge. I just don't want to waste anybody's time. That's
all right. Let's go. So this is the motion to revoke bond on case 2022 CR 00704. This is Marquelius Teray McNabb. Ms. McNabb is represented by the law firm of Lister Holt Dennis. Mr. Owen Lynch is with him. The state is represented by Deputy Chief Shabria Ponder. And they are ready to go forward with the motion. Ms. Ponder, you may call your first witness.
Thank you, Your Honor. At this time, Your Honor, the state is going to go out of order with witnesses based on officer availability.
That's fine.
Thank you, Your Honor. And so at this time, Your Honor, the state will call Trooper Angeles. May you please raise your right hand? Do you swear or affirm that the testimony that you're about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
Okay, may you please state your first and last name?
Trooper Ulysses Angeles.
Okay, and can you spell your first and last name for the court and for the reporter?
First name is Ulises. Last name is Angeles, Angeles.
And how are you currently employed?
I'm currently with Georgia State Patrol.
Okay, and prior to being employed with the Georgia State Patrol, were you employed with the Clayton County Police Department?
Yes.
Okay, and how long were you employed with the Clayton County Police Department?
Approximately 4 years.
Okay, and being employed with Clayton County Police, does it require you to be post-certified?
Yes.
On this date, August the 17th, 2023, were you in fact post-certified?
Yes.
In good standing?
Yes.
Okay. And being post-certified, does that give you the authority to issue citations?
Yes.
Does it give you the authority, to arrest individuals?
Yes.
Okay. I want to draw your attention to why we're here today, August 17th, 2023. Did you respond to 7830 North McDonough Street?
Yes, I did.
Located here in Clayton County, Georgia?
Yes.
And why did you respond to that incident location?
I responded in reference to a domestic violence call.
Okay. And during the course of your investigation, when you arrived on scene, did you make contact or did you speak with anyone? Without saying what they said, did you have a conversation with anyone on scene?
Yes.
Okay. And how many people do you recall speaking with?
I spoke to Mr. McNabb. I also spoke to his girlfriend at the time, which Chartria. Last name was Hutchison, Chartria Hutchison, and her sister, who was also present. Her name is Shakiria Hutchinson.
Okay. And so, so I just want to understand correctly, because I know there's a lot of information. Okay. And so during the course of your investigation, you indicated that you spoke to 3 individuals. Did you speak to anyone else?
Yes. It was a 9-year-old and a 7-year-old juvenile on scene as well.
Okay. And you spoke to the 2 children and the 3 adults.
Correct.
Okay. In the course of your investigation, after speaking to those individuals, did you make an arrest?
Yes.
Okay. And who did you arrest on that day?
Mr. McNabb.
Okay. And what did you arrest him for?
For battery, family violence, and cruelty to children, 3rd degree.
Okay. And did you yourself observe any injuries?
Yes.
And what were those injuries?
So Shartria had a cut on her hand. The sister, Shakira, had a bruise on her forearm.
Okay. And was, okay, you've answered that. No further questions. Thank you.
Mr. Lynch?
I'm listening. Just a couple questions, Officer Angeles. One of the individuals that you spoke to during the course of your investigation, I believe you indicated was my client, Mr. McNabb. Is that correct?
Yes.
And isn't it true that what Mr. McNabb told you is that he was jumped by his girlfriend and her sister, Shakira?
I'm going to object to that, Your Honor, unless the defendant intends to testify.
So I believe that it would be admissible under a statement by, it's 801, statement by a party opponent. It's what my client said is admissible because it's his own statement. I don't think he has to testify for that.
Your Honor, I will argue that it is hearsay. The counsel is wanting the officer.
Exclusion. I'm sorry.
Counsel is wanting the officer to testify to what the defendant said or get into what the defendant said when the defendant is choosing, which is his right, not to speak.
So it's a hearsay exclusion, Judge. It's admission party opponent.
1 second. Overrule.
So you can answer the question, officer.
And your question was, if you don't mind.
That Mr. McNabb told you that he was jumped by his girlfriend and her sister, Shakira.
Yes.
Okay. He also told you that he fell on the ground in the process of being jumped by Shartria and Shakira. Isn't that correct?
Yes.
You, during the course of your investigation, you were shown a video. Isn't that correct?
Correct.
And that video that you were showed, well, what did you see on the video?
On the video, I saw Shartria with some items of Mr. McNabb, in which a physical altercation ensued then. And I could see Shartria on the ground with Mr. McNabb. But after that, the video kind of cut off, so I wasn't able to see anything further.
Okay, so you were able to, how were you able to determine that the items that they had were Mr. McNabb's?
Believe Mr. McNabb told me those were his at one point, but I can't completely recall that.
No further questions at this time.
All right. Any redirect?
No, Your Honor.
All right. May this officer be excused?
I could just have one moment. Your Honor, if I could just hold this officer just briefly.
All right. All right. So Trooper, just if you will just hold for a moment, you can go ahead and mute and we'll call you when necessary. All right, next witness.
Your Honor, the next case, Your Honor, the state at this time will call Officer Covington. Good morning, officer. Are you able to hear me?
Yes, ma'am.
Okay. May you please raise your right hand? Do you swear or affirm that testimony that you're about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. May you please state your first and last name, please?
Name is Officer Leon Covington.
Okay. And how are you currently employed?
I am a police officer with the Clayton County Police Department.
And on April the 11th, 2023, were you in fact employed with the Clayton County Police Department?
Yes, ma'am.
And being employed with the Clayton County Police Department, are you post-certified?
Yes, ma'am.
Does it give you the authority to issue citations?
Yes, ma'am.
And do you have arrest powers?
Yes, ma'am.
And I want to draw your attention to this incident date, April the 11th, 2023. Did you respond to 6726 Terra Boulevard, Jonesboro, Georgia?
Yes, ma'am.
And is that located here in Clayton County, Georgia?
Yes, ma'am.
And on this particular day, why were you dispatched to that incident location?
I was dispatched there in reference to a disturbance call.
Okay. And did you make contact with anyone at that location?
Yes, ma'am. I made contact with the property manager of the location.
Okay. And do you recall the property manager's name?
I believe Miss Tyra Bailey.
Okay. And after speaking with Miss Bailey, what did you do? What did you learn during your investigation?
I learned that the defendant traveled over to the leasing office in reference to his residence being burglarized. He went to the location yelling and cursing and was asked to leave by security personnel, at which point the victim stated that.
So I'm gonna object to the victim's statements and on the basis of hearsay at this point.
Your Honor, I believe this witness is available. Miss Tyra Bailey is available.
Overruled.
Go ahead, officer.
I'm sorry, I gotta think where I left off. Yes, so he was asked to leave by security personnel, at which point the victim advised me that the defendant was issued a criminal trespass warning from the property prior to the incident.
Okay. And
Okay,
did you make contact with Mr. McNabb on that day?
yes, ma'am.
Okay. And at that point, did you make an arrest?
Yes, ma'am.
Okay. And what was the basis for your arrest?
So he was charged with criminal trespass. I verified that he was issued a criminal trespass warning through Clayton County database. Also, the defendant admitted that he was told to not come to the leasing office.
Okay. Thank you, Officer Covington. No further questions from the state at this time.
Okay, Pete, you mind sticking? Yeah, we're good, right? Okay. I'm gonna ask you some questions, officer.
Okay.
Sorry, this is a little different.
Okay.
So the criminal trespass warning that you're referring to, did you see a copy of it?
Yes, sir.
And where did it indicate that he was banned from going?
From the property at 6726 Terra Boulevard.
That's the entire apartment complex?
I can't recall if it was the leasing office or was it the entire complex.
Okay. But you stated that you learned that Mr. McNabb went to the leasing office because he was upset about his apartment on that property being broken into. Isn't that what you testified to?
Yes, sir.
Okay. So from that, it would indicate that he was currently living or had an apartment at that
I'm
apartment.
going to object, Your Honor, to speculation.
He can answer if he knows. He would have taken his address, I presume.
Did you learn during the course of your investigation that Mr. McNabb lived at that apartment complex?
Yes, sir.
Okay. Is it common, or in your experience as a police officer, that someone can be issued a criminal trespass warning from their own apartment complex?
Yes, in the case that if they have issues with management personnel, usually management would issue them a criminal trespass warning to prevent them from going to the leasing office.
Okay. All right. No further questions at this time.
All right, any redirect?
No, Your Honor.
Okay, may this officer be excused?
I could just hold this, officer.
All right, next witness.
Your Honor, at this time, the state will call Ms. Tyra Bailey.
All right, Ms. Bailey, may I see you, please?
Sorry, I'm trying to move my camera around so I can turn it on.
Okay, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
I do.
All right, you can put your hand out. All right, Ms. Potter, your witness.
Yes, Your Honor, thank you. Ms. Bailey, may you please state your first and last name and then spell your first and last name, please.
Tyra Bailey, Y-R-A, last name B-A-I-L-E-Y.
And how are you currently employed, ma'am?
I'm a property manager.
And where are you a property manager at what location?
Would prefer to not give my current location as it is still in the Clayton County area. And yeah, I'm sorry, I don't know if that's allowed, but I don't want to give my actual current location.
Well, where are you you're not comfortable with providing the
Okay, let me
The
ask this.
specific
Are you
apartment
still at the
community.
apartment? Are you still at the apartments you were at when this incident happened?
No, ma'am, but I am still at an apartment community in Clayton County.
Okay, just tell me where you were when this happened.
Oh, I was at an apartment community called Woods on Terra
Okay.
Boulevard.
And thank you, Runner. And how long were you employed with Woods on Terra?
With that company for 2 years.
For 2 years. Okay. And so on this particular date, April the 11th, 2023, were you the one to call 911? And why?
Had a previous run-in with Mr. McNabb, and even prior to me being employed there, I had viewed video and been advised that he had a criminal trespass against the leasing office. My first initial contact with him, I wasn't aware of that. So my supervisor and my assistant at the time ended up showing me the video and saying he's not allowed here because he had pulled a gun on the staff prior to me coming there. So the next time he came, we did advise him that he was not allowed to be in the leasing office. It was only for the leasing office, not the entire community.
Okay. And on this particular day that you called the police, what happened?
So the apartment was essentially deemed abandoned because the power had been off, and we found that squatters kept going into the apartment, but there was no power and it was deplorable. There was raccoons and animals in there. And so the first time I had encountered Mr. McNabb, we had like locked it because the door was wide open. So I had changed the locks and gave him a key. And then the second time he came, he said, well, somebody broke in again. I immediately locked the leasing office door because like you could see the parking lot from the top where it was above the stairs. And so when I saw him pulling up, he has a very distinctive truck and it's a loudspeaker. So I locked the door and told all my staff, don't leave. But as he came up the stairs, the security guard came from around the building and told him, you know, you're not allowed to be here. But then the security guard went and unlocked the door to tell me, hey, he's saying somebody broke into his apartment. At that point, Mr. McNabb basically tried to push past the security guard and enter into the leasing office. And I'm telling the security guard, shut the door, shut the door, shut the door. And then he finally got the door closed and we locked it again. And then I called the police.
Okay. And is that when the police arrived?
Correct. When the police arrived, I went down the stairs and I did advise the officer that he had a CT from the leasing office and he was not allowed to be there. And he did talk to Mr. McNabb, and then he came back and he said, well, he's saying somebody broke into his apartment. And I said, he needs to contact the police, you know, not come to the leasing office calling me names, yelling and screaming and pushing past the security guard to try to get, well, I can't speculate, but to try to get inside.
Okay. All right. Well, thank you, Ms. Bailey. No further questions.
Mr. Lynch?
So, Ms. Bailey, you wouldn't disagree with me. I'm not talking about the leasing office, but I'm talking about as far as that apartment, that my client had a right to be in the apartment on April 11th, 2023. Right? He hadn't been
Absolutely. He had a right to be in his apartment. Absolutely.
Okay. And you don't dispute that there had been a break-in well, let me ask you this. It was relayed to you by the security guard that he was coming up there to attempt to address the fact that he believed his apartment had been broken into. Is that fair to say?
That is correct.
And you also testified that the security guard actually opened the door and kind of relayed that message that he was there to raise concerns about his apartment being broken into. Isn't that
That is correct.
okay? Now, did he enter inside the leasing office at that point?
Yes, he did. He like the security guard, when he opened the door, he was like sideways and he's like, hey, he's coming up here because he thinks somebody broke into his apartment. And Mr. McNabb came through over top of him essentially and was like, you know, yelling explicitives and y'all are going in my apartment and all of this.
Okay. And then did he leave after he made those statements?
No, he was there when the police pulled up.
Inside the leasing office?
No,
So he did leave from inside the leasing office then?
yes. Mhm.
Did he do that at?
He didn't make it, he never made it all the way into the leasing office. He was just like reaching over, and so like his arm was made it in like half his head.
So
But the
just
security
his
guard was
arm-
standing there as a
I'm
barrier.
sorry. I'm sorry. So he didn't actually make it all the way inside the leasing office. He basically was trying to get through the door and he was making statements. Maybe his arm came through the threshold and he was making statements to you in regards to him being upset about what he thought was going on with his apartment. Is that fair to say?
That is correct.
Okay. No further questions.
Any redirect?
Yes, Miss Bailey, if you can recall the woods on Terra, where is the leasing office?
Leasing office, I would say, is mid the community. So when you come down a long driveway, we called it, and then you take a left and the leasing office is there in the center of the community.
So is it a standalone building or is within apartments?
Nope, it's a standalone building.
Okay, and how far, if you can recall, where his apartment was in the leasing office?
His apartment was in the very back of the community. So the driveway, it goes all the way to the back, and literally the leasing office is like the middle point of the community. And then when you go all the way to the back, his apartment was in the very back of the community.
And is there parking spaces designated just to the leasing office?
Yes, ma'am, that is correct. When you turn into the leasing office parking lot, that's only there's no apartments up there, and you have to go upstairs to get to the leasing office. It's
Okay.
a flight of stairs up, so it's even elevated from the parking lot.
Okay, great. Thank you so much. No further questions from this witness, Your Honor.
All right. May this witness be excused? Any recross?
No, Judge.
All right. Ma'am, you're free to go at this time. If you want to stay and hear the remainder of the hearing, you can just mute your device, okay? All right. All right. Does the state have any additional witnesses?
State has no additional witnesses, Your Honor, for this motion 2022 CR 00704.
All right. Is there a motion for the other case, or is this encompasses both?
It's for both, Your Honor.
All right. Does the defense have any witnesses that they wish to present at this time, or any evidence to present?
Look, I don't believe so, Judge, but can I just ask clarification as far as both motions that are to be heard today? Has the state presented all the witnesses, or are we going to do another motion after this?
I
So,
know.
Your Honor,
First, let me ask this. Are there 3 cases pending, or only 2 cases pending?
So, Your Honor, there are 5 cases pending.
Including
So I filed 2 motions to revoke bond, Your Honor, but they have the same witnesses.
Okay, that's fine.
The exact same witnesses would testify to the same information for both, because these incidents happened after he was arrested on both of these. Well,
Okay.
the battery family violence happened after the
Yeah.
2024
So I
CR.
got the April 11th, 2023, and then August 17th, 2023. And are y'all going to testify about the next case in the series, or these the only 2 cases I'm going to hear about?
These are the only two cases, Your Honor, that the state is moving to revoke based on the information that's provided. We didn't file a motion to revoke bond for 2024 CR 0. No, we did on that one.
I think it-
Yeah, so.
You did or did not?
We did not. On the simple assault, we filed a motion to revoke bond. In the simple battery, we filed a motion to revoke bond. The motion to revoke bond from the simple battery and terroristic threats, the case motion for the case August 17, 2023, and also the April the 11th, 2023. Those two
So-
cases. Yes,
What
sir.
I'm getting at is there is only one, if the case is being argued, there's only one bond revocation that I need to consider. And that's the bond that existed from the April 11th, 2023 case that was then violated by getting charges on the August 17th, 2023 case. Is that what the state is?
November 29th, 2021 case, the state filed a motion to revoke
Okay.
bond.
But I haven't heard anything about I haven't heard anything about that, or even that he
I'm
had
sorry.
case pending.
One moment, Your Honor, I'm just trying to get my,
Yeah, so what I'm saying is the only thing before the court is there's one violation of bond, because the bond that he had for the first case would have been the bond he violated to get the second case. Now, if there's an
Okay.
additional bond violation, I'm not hearing that there's a third case or a fourth case.
okay, Your Honor, so the state filed a motion to revoke bond 2022 CR 00704. The
Mhm.
incident happened November the 29th, 2021, Your Honor. That is
Which-
the very
which
first case that he had a bond on. Those bond conditions was on December 6th, 2021, where it was to stay away directly or indirectly from
Okay,
Shakira
but
Hutcherson.
what I'm saying is you haven't put that on the record. You filed it based on that, which would have meant that the April 11th would have been a bond revocation, would have been a bond violation, and the August 17th would have been a second bond violation.
Correct,
But
Your Honor.
I haven't heard anything on the record about this November. So you haven't given me that a bond existed or he was arrested and he
Well,
had
Your
a
Honor,
bond.
so when the motion to revoke bond was filed, those witnesses wouldn't be here because I am
No.
bringing,
What I'm saying to you is you haven't established that November bond existed. You haven't put anything on the record about a bond existing so that the April would have been a revocation event. You get what I'm saying? You got to first establish that he had a bond in November of whatever. You
that
haven't
is
put
correct,
anything.
Your Honor, and that's, yes, and that is part of the record that the state filed in their motions that was added to exhibit.
Okay, but so the motion and what we're hearing, you haven't put it on the hearing record is what I'm saying.
Oh, okay, I understand, Your Honor.
Okay, yeah, I get that. That's why I want to be clear, because what the transcript is what people are going to look at. They'll look at if there's ever appellate review, they'll look at the record, but they'll look at the transcript to see where the argument was made that there's two bond revocations. I can't just say, okay, well, I read the report and because I got to give Mr. Lynch a chance to respond to it.
Correct, Your Honor. So the state's first pending motion from 2022 CR 00704,
Mhm.
the court filed, the court ordered on December the 6th, 2021, and it was filed on December the 6th, 2021. Your Honor, the state will ask the court to take judicial notice based on this being a part of the record. This is with the clerk's office, and it was filed by, at the time, Magistrate Court Judge George. In
Okay.
this case,
All right, and those conditions said what?
in those conditions, Your Honor, the defendant was charged with simple battery and also terroristic threat. Your Honor, those conditions, it stated, stay away absolutely directly or indirectly by mail, email, pager, telephone, or third party from the person, home, workplace, and immediate family members of any witnesses included but not limited to Shakira Hutcherson. And I apologize, Your Honor, if I'm pronouncing Shakira incorrectly.
I got
And then his second bond condition, the defendant must not violate any laws while on bond. that was ordered on December the 6th, 2021.
All right, that's what I was trying to get at, because for what you presented with the officers, there was only one bond violation, but that establishing first that there was a bond existing from 2021 now gives me two bond violations to consider. All right, Mr. Lynch.
Well, I would object to the court taking judicial notice, but I do see that as Exhibit A to the motion, they did attach the bond that we're talking about here. I would point out, though, that if the court considers that being introduced, that this document is not signed by the defendant, it's not dated. So I guess, is this my time to argue, Judge?
No, this was establishing that I'm clear on what the record is.
Okay.
It has been admitted as an exhibit to the motion. I'm fine with that. I just wanted to get it on the record here during the hearing that there was another bond existing. Now, it's because it's part of the record, I don't have a problem with acknowledging it and taking judicial notice, but the reason I wanted to also read the actual bond conditions was because we have run into that situation where I don't know what magistrate was doing, but there was bond conditions that did not also say that you can't have additional criminal charges filed. So I wanted to make sure that we were clear on everything that it was consistent with what I understand the bond conditions to be. All right, so now the state doesn't have any other witnesses to bring. The defense doesn't have any other witnesses, so I will hear argument.
Yes, Your Honor. Your Honor, so the state filed a motion to revoke bond in case 2022 CR 00704. As the state requested, Your Honor, the state has requested that this court take judicial notice of the defendant's bond conditions. Those bond conditions, which is part of Exhibit A on the court's motion to revoke bond. It was ordered on December the 6th, 2021 by the Honorable Judge Sonia George. As the state, in the order, it states, she'll stay away absolutely directly or indirectly by mail, email, pager, telephone, third party from the person, home, workplace, and immediate family members of any witness, including but not limited to Shakuria Hutcherson. SHAYQUREIA Hutcherson HUTCHISON. And lastly, another condition was the defendant must not violate any laws while on bond. Your Honor, you had an opportunity to hear two separate cases in which the defendant did display some type of violent nature. In one of his cases, Your Honor, you heard from Trooper Angeles, who indicated that he did arrive on scene and spoke to a Shantaria Hutcherson and a Shakuria Hutcherson. Your Honor, one being the sister and one being the defendant's child's child's mother. Also, you've heard from the officer that there were injuries that he observed himself. He indicated that one of the witnesses had I just want to make sure I have that correctly. He indicated that one of the witnesses had a cut to her hand and another witness had a bruise to her forearm. He did indicate that he spoke with the defendant, Mr. McNabb, which is a violation of his bond conditions. One, him being there and in contact with Shakuria Hutcherson. And then two, Your Honor, he picked up new charges for battery, family violence, and cruelty to children. As the court heard, there were minor children there, a 7-year-old and a 9-year-old child. Furthermore, Your Honor, there was an instance where there was another case where Mr.
If we're talking about a case that hasn't been introduced, are we getting into a case that we didn't deal with on the record here?
There were two cases we spoke about.
Sorry.
Okay.
Go ahead. I didn't mean.
And not only, Your Honor, did he pick up this case on August the 17th, 2023, that was the first case that the court did hear. However, he continued to pick up a case even before that, September the 20th, 2022. In this case, Your Honor, you heard from the actual victim in this case, Miss Bailey, who was at the time the property manager. She testified that, to her knowledge, Mr. McNabb received a criminal trespassing warning from the actual leasing office because he had an outstanding case where he is her understanding, her knowledge that he pulled out a gun and threatened someone at the leasing office. So therefore, he was told that he could not come back. She did testify that the leasing office is not the same location as his apartment. His apartment is in the back. The leasing office is standalone, and that is another case, Your Honor. So while out on bond from 2021, the defendant has picked up 2 other cases which is violent in nature. One, a battery, family violence, and cruelty to children in the 3rd degree, and also a criminal trespass in which the victim did state that he was criminally trespassed from that leasing office, where he began to shout and scream profanity. And so for that, Your Honor, the state will ask this court to revoke the defendant's bond.
All right, Mr. Lynch.
So, Judge, I'm going to get into the factual allegations and discuss the 2 cases that the state has alleged to be violations of his bond. But first, I do want to speak a little bit about Mr. McNabb. So Mr. McNabb is he's 33 years old. He does have 4 children with Shartria Hutchinson, I believe. He is currently working. He works at a warehouse where he's worked for the past, it's been over a year. He does order fulfillment. Judge, I would also point out that since the August 2023 incident, he has had no arrests. There have been no further allegations of him violating any bonds. So I point that out first, Judge, just to kind of get back into the allegations as far as the battery family violence case. So I believe the officer testified that this is the location where he was living with his mother's, the children of his mother, Shartria Hutchinson. He didn't have a previous case with Shartria Hutchinson. I understand that there was a previous case with Shakia Hutchinson, her sister, but he's at the residence of his baby's mother with his children at the time. And I think
do you understand that if Shakia was named on that's why I asked her to read into the record, the bond conditions. If Shakia was named, then a close family member of hers would be her sister, and he would have had to stay away from her too, unless he got a modification of bond.
And I understand that, Judge. However, Your Honor, and I understand the point that you're making. However, there was no evidence about who came to the location first, whether he was there and the sister showed up. So the court doesn't have that evidence that he, intentionally placed himself in a position with Shakia Hutchinson, who he had actually been given bond conditions to stay away from. Additionally, Judge, that Exhibit A with the bond conditions listed, I would note that it is not signed or dated. So there
you just glossed right over what I said. You know that, right?
No, I didn't mean to gloss over it, Judge. I thought
Shakia is the person on the December 6, 2021 bond. Is that correct?
Correct.
Then Lord, this is difficult. Then Shartria would have been her close family member that he's not to have contact with. If he goes back and lives with Shartria, I don't care if that is his baby mama. She's a sister of the woman who has a bond condition.
Well, Judge, and I understand that point. However, again, the bond conditions that were allegedly, presented to him, there hasn't been evidence that he actually was put on notice of that because there's no signature there, Judge. And, that is something that I feel like would need to be spelled out explicitly, because whether or not it has to be, it certainly should be, because Mr. McNabb is a provider for his children. He does work. And, I would argue that there needs to be very definite, concrete notice if he is going to be in a position where he's not allowed to have contact with the mother of his children, because
Other than actually write it down? Because, if you've never been to a first appearance hearing, we're talking about sometimes up to 20 and 30 people in the room. The judge is going person by person. We're not taking a deep dive, but on the paperwork, it says exactly what it says, that you're not to have contact with the family members of these individuals.
Well, I understand that, Judge, but I don't know if the client can anticipate that that would apply to the mother of his children.
Okay, go ahead.
Additionally, Judge, I'm sorry, I lost my train of thought there. Mr. McNabb is certainly presumed innocent on that case, and I don't think there's evidence that he intentionally violated that bond, Judge. And even, Judge, even if you consider that a violation just based on him being around the mother of his children, Judge, I would, setting the criminal trespass aside for Judge, I would ask the court to consider alternatives to revoking his bond, considering it is understandable that a man who is taking care of 4 children with a woman, and that they're actively raising the children together and cooperating, it's understandable that if it wasn't explicitly stated you cannot have contact with the mother of your children, that he wouldn't just, and I understand it's written there on the paper, Judge, but I'm also asking you to consider the realities of how people live and family dynamics, Judge. It's a great surprise to many defendants that these orders that they're given would apply not just to the alleged victim, but also to, their family members and people who they have to deal with on a regular basis in the rearing and the support for children, Judge. And I would also ask you to consider the fact that Mr. McNabb is currently employed. He has been employed for over a year at the same facility, Judge. He hasn't got any additional charges since 2023. You asked him via Zoom to come in here and appear before the court. He has done this. He's not running away from these cases, Judge. He only asks that you allow him to remain out on bond and be able to face these cases individually. The other allegation of bond violation was the criminal trespass, Judge. This is at the apartment complex where he lived. He was raising a concern with his living space. And I understand that you could call it a technical violation of him going into the leasing office, but I don't know. He has got to try to address the fact that his apartment has been broken into in some manner. And that's all the evidence supported that that's what he was doing. He didn't make it all the way into the leasing office. Ms. Ponder has characterized his behavior as violent, but he didn't attack anyone. He didn't, it seems that he stopped at the doorway and didn't, there's no indication he was attempting to initiate physical contact. And again, that's, something that would not necessarily, he may not have thought about when he's returning to his place of residence, his apartment, and trying to address concerns with the fact that his apartment had apparently been broken into, and even the leasing officer testified that his locks were changed, Judge. So you know, he obviously needs to get access to his apartment and needs to have these issues concerned. I don't know if there was ever any sort of alternative mechanism for him to address these concerns with the leasing office that, you know, didn't involve him going into the leasing office, Judge. And again, Judge, you know, I understand magistrate court, there's a lot of cases, but that exhibit is not signed or dated. You know, no additional evidence was presented as other than that paper that was filed with no signature. There's no additional evidence of how that notice was relayed to him, whether he got a copy of that, whether that was presented to him. That was not presented, Judge. But my main argument, Judge, I understand that there's several cases, Judge, and ultimately these cases are going to be resolved. And if he's convicted on one or more of them, Your Honor, obviously will be in a position to evaluate all the facts and all the considerations and issue a sentence. But I would ask that instead of putting him in jail now, which would destroy his ability to support his family, to keep his job, I would ask that you instead admonish him about what bond conditions do exist. If Your Honor wishes to impose additional bond conditions, but allow him to remain free unless there are additional bond conditions so that he can have his day in court and present his defense, Judge.
And Your Honor, may I
Yes, ma'am.
Your Honor, so regarding the bond modification, I'm sorry, the order for bond, as the court is aware at that time, it was during COVID or during the pandemic in which they were not giving utensils in order to write, where magistrate court, Your Honor, was speaking to them verbally, and at that point they will understand. Your Honor, even if the court saying, hey, there was no signature, or if counsel is arguing that there is still IOLA factors that this court can take in consideration that doesn't require even bond conditions. And four of those factors, Your Honor, is whether one of those is whether he's a threat to witnesses or he's a risk of committing another crime. And I submit to Your Honor, Mr. McNabb has been out in custody since 2021. And every year since, except this year or last year, he has not picked up a new case. And Your Honor, it's not just traffic offenses, but these are cases where there are victims associated with these cases. Even if, as counsel did not want to go into detail and harping on the fact that he was around his sister, his child's mother, or he was around the sister of his child's mother, he failed to mention that the officers indicate that there were some bruisings to both individuals, but not that his bond conditions was not to violate or pick up any new offenses while out on bond. Not to say that he is found guilty for any of these, Your Honor, but more so him just picking up those charges. As you've heard from Ms. Bailey, Your Honor, as I will indicate, she stated that he was trespassed from the leasing office because the prior case in which the defendant had a firearm and made threatening statements. So not only did she fear to the extent where she had to lock her doors of a business, where she is a manager of, she is here today, she testified, and she's not even working at that location. And she still appeared, Your Honor, before this court to tell the court exactly what happened on that day. I believe when counsel makes reference to the fact that he is a father and he's a provider, he should have thought about it, that, Your Honor, before he picked up new cases or before he picked up those violent offenses in front of his children, that 7-year-old and 9-year-old child that was present at the time that he picked up those cases against their auntie. Your Honor, so at this time, I will ask this court to revoke the defendant's bond.
Judge, the state indicated that the IOLA factors include, you know, threat or risk of committing additional crimes, but I believe it's risk of committing felonies, additional felonies, Judge. But I understand the concern. Again, Judge, I would just fall back on our request to the court, what we've argued as far as
Hey.
the,
Okay. The issue that I have with this is that, well, first, I wish that this had been brought to my attention with respect to a bond revocation much earlier, because definitely time plays a factor in all of these things. But the thing is, I don't know how you back to back, like, you got to be clueless to not either read your bond conditions. I know I've been a magistrate, so I know they're telling you what your bond conditions are. You get a copy of your bond conditions at the jail. You can get a copy when you leave by going to the clerk's office. You know you have bond conditions. So it's incumbent upon you to know what they are. What your argument rests on is, I'm supposed to accept the fact that he was too dumb to go figure out what his bond conditions meant. And then he continues, he got either an anger issue, something's going on. I mean, because he seems to make contact with the police way more often than a lot of other people. And while I do want the man to be able to support his children, I don't have any evidence that he actually is supporting his children, other than what you said. When you have a violent event that occurs in front of children, I don't understand, like, he's not going to be father of the year by any means.
I was young.
And the fact that, you get trespass from the leasing office at your apartment, even if his apartment was burglarized, Mr. Lynch, that's the police respond to that. What did he think the leasing office was going to do? Other than, hey, my apartment got burglarized, as they happened before. But I don't know that Mr. This is really problematic on several levels. It's problematic from the standpoint of the state, because he's got 5 cases that I know of, and the 3 y'all arguing about the bond conditions for the first one and the 2 that came after that. I'm just really just getting to know about them, which I get it. And then he's got a criminal trespass from the place where he lives. I just don't understand. On both sides, there are issues. The only thing that makes me not want to violate his bond is that he's actually working and has a job. But I don't have any indication from anybody that he's actually taking care of these kids. I don't have any indication that you don't fight in front of your children if you actually taking care of your kids.
Judge, and I understand that. I mean, and I know I can't.
I don't know what other admonishment you want me to give him, Mr. Lynch. I give admonishments every time I talk to people. I know the judges in magistrate court give admonishments. They tell you what the bond conditions mean. Unless it's changed drastically, they even tell you what the possible repercussions are of violating your bond conditions. If you violate your bond condition, you could get your bond revoked. You could come back to jail and stay in jail until such time as you resolve all of your cases. And so I don't know, like, how much more we got to tell Mr. McNabb. There's somebody who said, if you want to hide something from folk, put it in a book or put it on paper, and they're not going to read it. And I feel that way about bond conditions. If there's nothing more important to how you conduct your life, it's bond conditions. Read it, understand it. If you don't understand it, ask questions. But people get locked up and they don't ever think about, well, I got bond conditions. They don't think about anything that means, and it's written out. And so I don't know that we need to keep using dumb as an excuse.
And, Judge, I wasn't certainly not meaning to imply that Mr. McNabb is dumb. I don't think that is the case.
Well, not willing to read his bond conditions and get an understanding of what they mean.
Your Honor, I think that's state's position is that's an excuse. After one case, that's fine, Your Honor, but he has multiple cases before the court. And as soon as I learned about this, Your Honor, I myself filed a motion to revoke bond because of how egregious in nature, in my opinion, it is. But I don't think that the court should just slap Mr. McNabb hand on the wrist because the state didn't catch it in time, or the fact that he has a job when he knew he had a job then. And so I can understand one case give grace, but he has multiple cases. So it's as if he's just turning his nose up to the system, hoping that, oh, I have kids and I have a job. Please keep me out.
All right, at this time, Mr. McNabb will be taken into custody. Bond will be revoked.
Judge, could I ask you to reconsider? Mr. McNabb certainly is presenting himself to you. I've argued he hasn't caught additional cases, Judge, and he's willing to comply with any
Well,
additional.
I mean, how many more would he need, Mr. Lynch? He got 5. I'm considering 3 in front of me. But I mean, really? Yeah. At this time, Mr. McNabb will be in jail until such time as his cases are resolved. Get me an order, Ms. Ponder.
I will, Your Honor.
All right.